Hello everyone, I extend a warm welcome to all the students watching today's lecture. I shall be discussing about the types of companies today. This is part 3 of my series on types of companies. Now before starting with the types of companies, I would like to recapitulate. A company may be described to mean a voluntary association of persons who have come together for carrying on some business and sharing the profits arising from such business. The company has perpetual succession and is a separate legal entity, meaning it will continue forever unless dissolved by legal process called winding up. Though generally companies are formed for the purpose of earning profits, there can be companies which are formed for charitable purposes, for promotion of some type of sport or art, science, culture or religion. The company form of organization is governed by Companies Act 2013. The Act contains 470 sections, 29 chapters and 7 schedules. Now coming on to types of companies, many different types of companies can be registered under the Companies Act 2013. They can be classified on the basis of liability. We have companies limited by shares, and companies limited by shares are a company limited by shares means a company having a liability of members limited by the memorandum to the amount unpaid on the shares respectively held by them. Then the second type is companies limited by guarantee. It is a company having the liability of its members limited by the memorandum to such amount as the members may respectively undertake to contribute to the assets of the company in the event of its being wound up. So, that is what a company limited by guarantees. Then we have unlimited company also, and companies having no limit on the liability of its members are known as unlimited liability company. While the fourth type, a private company means a company which by its articles restricts the right to transfer its shares, except in case of one-person company, limits the number of members to 200 and prohibits any invitation to public to subscribe to any securities of the company. Then public company means a company which is not a private company. Already I have discussed in my earlier parts the conversion of public company into a private company. Then today I shall be first of all discussing about conversion of private company into a public company. So when it comes to conversion of private company can be converted into a public company by following the procedure which is laid down in the Companies Act 2013. Section 14 of the Companies Act provides that a company may, after alter its articles, including alteration having the effect of conversion of a private company into a public company or a public company into a private company by passing a special resolution. The procedure which is to be followed for conversion of a private company into a public company is as board of directors. The first step is board of directors are to convene their own meeting after giving a notice of 7 days. So, a notice of 7 days is required for the board of directors meeting. Then the conversion is to be approved by board of directors in their own meeting, and then they have to decide the date, time, venue of general meeting to pass the special resolution. After they decide on it, a notice of 21 clear days is to be given to shareholders, auditors, directors, etc., along with the explanatory statement for the proposed special resolution. Then they have to give a notice to their shareholders, auditors, directors, etc., means all the stakeholders, and that notice has to be a 21 clear days notice. Clear days means the day on which the notice is posted and the day of the meeting should not be counted. In between there have to be 21 days. That is the meaning of 21 clear days, and an explanatory statement has to go with the proposed resolution. Explanatory statement contains the details about the resolution, about why the company wants to get itself converted from its present status. So, that has to go with the agenda for the meeting, so that everybody comes well informed at the meeting for taking a decision. Then the shareholders general body meeting is held, and special resolution is passed in order to delete the restrictions of section 2 subsection 20 subsection 68 which are there in the articles of association, which restricts a private company from doing certain things. So those restrictions are removed so that that particular private company becomes a public company. And also the word private is deleted from the end of its name, and the word limited is it remains. Then the next is filling of MGT 14, which is a form with the registrar of companies within 30 days of passing of the resolution, along with the notice of notice of the calling of the meeting, a copy of special resolution, altered articles of association, and memorandum of association. So all this has to be filed in a form known as MGT 14 with the registrar of companies. Now form MGT 14 is for filing certain resolutions by the company to the registrar. That is the basically the purpose of form MGT 14. Now after that, form number INC 27 along with the fee must be filed with the registrar of companies, accompanied by altered articles of association and memorandum of association. So after filing of MGT 14, the next thing is to file form INC 27 with the registrar of companies. Form INC 27 is to be filed in case of conversion of private company to a public company. That is the purpose of form INC 27. Now within 30 days of filing of form number INC 27, the registrar shall issue a fresh certificate of incorporation if it is satisfied that all the requirements have been complied with. So then if the number of members of the company are less than 7, because 7 is the minimum number of members that have to be there in case of a public company. Therefore, since it was earlier a private company, it could be having members less than 7. So the number of members have to be increased to 7 at least, if not more. And if the number of directors is less than 3, because a public company has to have minimum of 3 directors. So if it is less than 3, then it has to be increased to 3 directors. And then if the company plans to raise funds through public offer, then a copy of red herring prospectus has to be filed with the registrar and SEBI. So after conversion of a private company into a public company, it may want to go in for a public issue, it may want to raise money from the public. It can remain in that it can raise money privately as well, because a public company has the option of raising money either through public subscription or through private placement. But in case it wants to go in for a public subscription, it has to issue a red herring prospectus. A red herring prospectus is a prospectus which contains all the details of a normal prospectus, with the difference that it does not contain the detail about the price and quantum of securities to be issued by the company, and it is used in the process of book building for determining the price of securities. Now, when a private company as such commits any default in complying with the restrictions given in its articles, for example, membership increases beyond 200, which is the maximum limit which is prescribed for a private company, or invitation is made to the public to subscribe to securities by a private company, which is again prohibited, then the registrar of companies suo motu shall send a notice to the for the conversion of that particular private company into a public company. So that can also happen in case of certain defaults. So this was about the conversion of a private company into a public company. Then the next in our classification of companies, I will just again go back to that earlier slide. We have just now completed with the companies on the basis of number of members. I have done private company and public. Then the next one, classification on the basis of number of members is one person company. And one person company has been explained in section 2 subsection 62 of the Companies Act. Now, what actually is a one-person company? What the name suggests, one-person company is a company where there is only one person as a member of the company. So, one-person basic company is basically a special form of a private company, and it can have only one member and not more than that. So, if earlier we used to have this sole proprietorship, a form of organization, which was not a very convenient method of doing business. So, to take care of the drawbacks of that sole proprietorship, in which the advantage of separate legal entity was not available, this concept of one-person company was introduced in the Companies Act. So, one-person company as per section 2 subsection 62 means a company which has only one person as member. Rule 3.1 and 3.2 of Companies Incorporation Second Amendment Rules 2021 specify that only a natural person who is a citizen of India, whether resident or otherwise, is entitled to form a one-person company or become its member. So, a person who is a citizen of India, that is the requirement. He can only form a one-person company. Whether that person is a resident of India or not, that is not important. So, that is one thing. Then a one-person company can only be formed as a private company. That is of course there, since it is a special type of private company. It can be a company limited by shares, it can be a company limited by guarantee. That depends upon the choice of the person starting the one-person company. The name of the one-person company must end with OPC. So, OPC stands for one-person company, it is the short form of that. So, the name of the company must end with OPC, that is a requirement, and an OPC cannot be converted into a Section 8 company, that is another requirement. Though an OPC cannot, and another thing is that an OPC cannot be formed as a non-banking finance company or a Section 8 company. So, OPC can be any company, but a non-banking finance company cannot be formed as an OPC, and also a Section 8 company. Section 8 company is an association not for profit making. So, if somebody wants to start a one-person company, he or she cannot start a non-banking finance company or a Section 8 company. And a person can't be a nominee of more than one-person company. That is another requirement. A person cannot be a nominee of more than one-person company. He can only be nominee of only one-person company. And a minor can neither be a member nor be a nominee of a one-person company. That is another requirement. Then a one-person company can be converted into a private company or a public company anytime. Earlier, the provision which was there was that conversion was allowed only after completion of 2 years from incorporation. But now this thing is not there anymore. A one-person company now can be converted into a private or a public company anytime, with the restriction of course that a one-person company cannot be converted into a Section 8 company. That is association not for profit making, and it can also not be started as a non-bank finance company or can be converted into a non-banking finance company. That is not possible. Then a one-person company shall give consent to become a nominee in form INC 3, which is filed with registrar along with the memorandum and articles. The nominee shall, in event of subscriber's death or his incapacity to contract, become the member of the company. So, person has to give his consent in form INC 3, which is filed with the registrar, that he wants to be a nominee. He accepts the nomination to be a nominee for the person who is the member of the one-person company, and he shall become the member in the event of the death of the original person who is presently the member. He has to give his consent in form INC 3. Then this new member shall nominate within 15 days of becoming the member a person who shall, in the event of his death or his incapacity to contract, become the member of the OPC. So, this nomination which is done has to be done within 15 days of a person becoming the member of an OPC. So that is a requirement. It has to be done very quickly as soon as the person becomes a member of OPC. The registrar shall be intimated about cessation of previous nominee and the new nomination by the company within 30 days. So if previous nominee ceases and new nomination is there, the registrar has to be intimated about it within 30 days of the change in membership in form number INC 4 after taking the prior written consent of the person nominated in form number INC 3. So whenever there is any change in nomination or the nominee himself becomes the member, say for example if something happens to the original member, the nominee becomes the new member of the company, then it has to be informed to the registrar of the company in form INC 4, and a written consent has to be taken again of another person whom that new member is going to nominate. Now as per section 149 subsection 1A, and OPC may have one person board of director. If the articles do not mention any director of an OPC, an individual being member shall be deemed to be its first director until the director or directors are duly appointed by the member in accordance with the provision of section 152. So section 152 lays down the provisions of how director is to be appointed in case of an one person company. So if the articles do not mention any person is director of OPC, an individual who is a member only shall be deemed to be the first director until the directors are duly appointed. So that is another requirement. Then Rule 7A of Companies Incorporation Rules 2014 provides that if a OPC or any officer of such company contravenes the rules with respect to OPC, then OPC or any of its officers shall be punishable with the fine up to 5,000 and a further fine of 500 for every day of default. So that is that calls for huge penalties if either the OPC does not follow the rules and regulations laid down in the Companies Act, then it is going to be fined rupees 500 and rupees 5,000. So 5,000 and further a fine of 500 for every day during which the default continues, and this fine is applicable, the same amount is applicable to both the individual as well as the company. So it is in case of continuing default, rupees 500 per day is what the fine is going to be charged from a company or member whoever is in default, and 5,000 is one time fine which is going to be charged again from the company if it is in default, and from the member also if the member is in default. So and one more thing I want to just again reiterate that OPC will be having one person in the board of director, but again this is not the maximum, though it will have only one member and not more than one member, and just one nominee, not more than one nominee. But when it comes to directors, one person can be a director of OPC, and that is the minimum requirement. There can be more than one people as director, one person as director of the OPC, and the maximum is 15. But one is the minimum which the OPC at least needs to have as number of directors. So with this I come to the end of part 3 of types of companies, and I hope all of you have understood about various types of companies, namely companies limited by shares, company limited by guarantee, unlimited liability companies, private companies, public company, and one person company. And we will continue with the remaining companies in the next part. So thank you. Keep reading, keep learning. Thank you so much.